Since this last topic was so controversial, we're going to move to something that is not controversial at all. This next panel is, of course, the our IPSJ Roundtable, the aftermath of In Re Tam, a case that resulted in a great deal of heated debate. And before I turn it over to the moderator for this panel, Professor Stephen McJohn from the Suffolk University School of Law, I wanted to apprise everyone that when you go through the written materials that we provide along with in your brochure, there are a couple of things in it that you might want to note. One, there is a collaborative article that we did with HIPAA on doing IP social justice around the world, and you get an excellent description of some of the boots on the ground projects, the various countries that they have been in and are in, and so you may want to have a look at that. And then someone reminded me, and matter of fact it is our co-chair, Tasha Bunch, reminded me that when we were putting together the excuse me, the materials for the In Re Tam, that way back in 2001, when we did the first IP social justice law review symposium in the country, it was in a 2005 volume of the Howard University Law Journal. The second one in the country was done by Berkeley in 2006, beat them by 1 year. There was an article in there discussing the constitutionality of the disparaging mark and scandalous, that whole topic 12 years ago. And the author, concluded that, drum roll if you please, that the United States Supreme Court would hold those clauses to be unconstitutional. So talk about IP social justice being a tad ahead of the curve. With that, I will turn it over to Professor Stephen McJohn. He will be the moderator and he will introduce the rest of the panelists. And just buckle your seatbelts. This is going to be interesting.
Okay, thank you, Professor Fatima. I do find this venue a little intimidating just because of the depth of the experience and expertise that we've assembled for the panel here in trademark law. Starting from my immediate right, Tony Hickey, who's Chief IP Counsel at Cummins. Philip Hampton, who was at Haynes and Boone, and among other things was in charge of the trademark office for a period of time. Bill Thomashour, who's at Prior Cashman, has litigated in this area for over 40 years, and Doug Retzu, who's the leader of the trademark and copyright group at Finnegan Henderson. So we're going to talk about TAM, maybe a critical look at the TAM opinion itself, and the effects in many directions that TAM has. And Bill Thomashour is kind of going to start us off.
Thank you, Steve. So, TAM was recently decided in June of 2017 by the Supreme Court after coming off an en banc decision by the Federal Circuit, which had a number of different opinions. And by now, most of you know what TAM was about. And I'm going to spend a lot of time on the merits as opposed to the arguments. TAM was an individual in a rock group, or Asian American rock group, and he wanted to register the slants, which was deemed to be, apparently not even deemed, admitted to be a derogatory term for Asian Americans. And he said he wanted to register it to take it back. At all levels, it was deemed to be disparaging. Section 2A of the Lanham Act says you can't register disparaging, also says you can't register immoral and scandalous and vulgar words, but we'll come to that in a minute. But certainly on disparaging, you can't register those. That's been the law since 1946. Representative Lanham proposed that as part of the statute. It was passed effective 1947, before even Phil Hampton and I were around.
Don't throw me under your bus.
Well, not before Don Dunner was around.
Okay.
But anyway, so that's how long that thing's been on the books, and it's been fine for 70 years until now the Federal Circuit and the Supreme Court have tampered with it. And so they concluded that, both the Federal Circuit and the Supreme Court concluded that this would be unconstitutional to restrict registration of disparaging marks. And so TAM, in theory, can can do that. He can register that. Now, the danger with that is that it opens Pandora's box, right? Now, under Section 2A, everything that couldn't be registered because it involves some kind of element of speech could now be registered. And so, if you looked at the history of the Trademark Office, the immoral and scandalous has been on the books for over 100 years. And a lot of scandalous and immoral and vulgar marks have been turned down for registration. And now all those can be registered, maybe. We'll come to that. Disparaging, same thing. You can think of the most disparaging epithets you want, and in theory now it's unconstitutional to prevent those from being registered. So I want to criticize those. I tell you right up front that I'm critical of the Supreme Court and of the en banc decision, close your ears, Judge, of the Federal Circuit, and for good reason. I think that there's some really good arguments that for some reason never made it to the Supreme Court, and I was frankly disappointed even with the Supreme Court's failure to address some of the excellent points in the Federal Circuit decision, such as the word chill. The Federal Circuit was concerned that if you don't register these, you will chill free speech. The word chill doesn't appear in the Supreme Court decision in TAM. Why is that? You have to explain what's the problem. So the first aspect that everybody should understand is the reason this statute was not a problem for 70 years was that the Federal Circuit, and before that the CCPA, which preceded it, had all said, well, there's no constitutional problem here because you can use these bad words, these disparaging words. You can use them. We just don't want to register them. The statute says don't register them. You certainly get extra important rights for registration. But Congress has made a value judgment that we shouldn't register these, but it's not a First Amendment problem. You can use them abundantly, as much as you want. And I will be speaking on this in my afternoon program that also covers the ethics of whether you want to represent somebody who wants to register or use disparaging and scandalous marks. But just on the concept of use, so for 70 years it was pretty clear that there was no First Amendment problem. That was stated in a Holiday Inn's decision by Judge Rich, who I had the pleasure of arguing before twice when he was still on the circuit. And he was also a very smart trademark lawyer. And he said, no constitutional problem, just use it as much as you want, but you can't register it. Holiday Inn's 1976. Later on, there was the McGinley case, which said the same thing, no problem, just use it. Even in the case of Mavity Media, which was more of a vulgar mark, they said, well, but you can use it, so there's no constitutional problem. All of those three cases mentioned and discussed and dealt with by saying it's not good enough in the Federal Circuit en banc decision, none of those three cases mentioned by the Supreme Court. Where is the discussion of you can still use it? That's what I was looking for. It's not there. I don't know whether it was the amicus briefs didn't touch it, but that's pretty important. So Doug's firm put out an article after TAM saying, well, where's the connection? And they said, well, the connection is the chill connection. You know that article. But the Supreme Court didn't mention chill. You did, I did, but so maybe that's the connection. Is it chilling? So I think that's a question. I think when you, as a policy matter, it seems very clear to me that when you weigh these two issues, since you have the freedom to use these words, you want to sell merchandise with these words, please go ahead. This is a free country. Please do that. That's fine. But we don't have to register it. A second aspect, which I thought the courts got wrong, was to say, well, this is the government making a judgment as to what's disparaging. It's not the examiner sitting there and looking at it a priori when it walks in the door and says, oh, this looks disparaging to me. It's not the TTAB, 3 judges saying this looks disparaging. This is adjudicatory. It's not censorship. It's adjudicatory. It's no different than if a federal judge has brought a defamation case and has to decide based on the evidence if something's defaming or not. Okay? The question here is this disparaging? We don't decide this on a tabula rasa, blank piece of paper. We decide this on a record that's done in an adversarial process. Both sides bring their evidence to bear on whether it's disparaging or not. And so our system is designed in the adversarial process to make those kinds of decisions. Let the TTAB and the judges do it. And as Judge Dyke said in his dissent in the en banc, he said, this isn't the government deciding what it doesn't like. There's an objective test laid out in the TMEP. So let's apply the objective test and let's run it that way. And I agree with that. I think that's the way to do it. So you have a test for it. You let both sides put in their evidence. TTAB decides. If you don't like what they do, you go to the district court. or you go to the Federal Circuit, as the case may be. And again, you have judges deciding on a record. That's a fair way to do it. It's not government censorship.
But the government's only deciding on a record on those cases that are appealed. If you're like the folks in TAM, there was no other side. This went from an examining attorney
Right.
who said it wasn't registrable to TTAB who said it wasn't registrable.
Right.
And there was some, but not a lot of chances to put in a whole record. Now, granted, if you're granted and it goes to, and somebody opposes you,
Right.
yeah, at least at that point you do have an inter-parties
Right.
situation. But and you said go back to the TMEP. And as the former commissioner of trademarks, I don't know if the TMEP it quite hits a home run.
Not objective.
Is not totally objective. Trademark Office has been and still is a fairly conservative organization, and I don't think that it really hits it on the head. I believe that the biggest problem has always been is that the first line is an examiner who has 42 minutes to make a decision.
Right.
42 minutes. So this examining attorney, right, and so a lot of it is their sensibilities. When they walk in the door, what is their sensibilities? I mean, when I was the commissioner, I got a visit from the Sons of Italy, and they were very upset with certain trademarks that were being registered that they felt were disparaging to Italian Americans. You know, and some of them I could see, and some of them I really couldn't see. Like an Italian woman in New York, who I guess was older, got a registration for Mafias. I mean, is that truly disparaging? They even didn't like the Godfather Pizza registration. Now again, you know, I'd always considered myself to be a fairly sensitive sort of guy, right? I know some people don't agree, but I couldn't quite grasp a couple of them. So, you know, the problem with, I think, disparaging in particular, but even now we're going to dovetail into the immoral and scandalous. Can somebody tell me why Madonna was rejected from registration as being immoral for wine? Somebody was making a hell of a value judgment to say that that's immoral.
But when was it though? That was was that the
70s?
70s.
No,
Hold on,
that's
that's
longer
longer.
ago than that.
Hold on, I got the site here. Keep going.
I think it was a product of the times.
Yeah.
Well,
but
we'll come to that.
But I mean, you know, what's a product of the times, right? I mean, so we're supposed to, you know, how did we get past that?
It does change. It
So
does
two
change.
things here, as a former examiner that had 42 minutes to examine applications.
Let me just say, Madonna was 1938, so the rules
So it's
were...
a long time ago.
Yeah.
And the examiners are actually examining with computers. So when they sit down in the first 5 minutes, all they have to do is Google a term. They know whether it's disparaging to a community. So it's not the examiner sitting there making a
priori,
representation
right.
about how they feel about it.
Exactly.
They're actually looking to see what is being said on the internet and other spheres about that term. So I don't think that you can just dismiss this as
No,
something
you don't
the
dismiss
examiner's
it.
doing
If
due
it's
to a
one
time
word,
element.
if it's one word, maybe. But how about the one that I personally was offended by when I was there, the Blacktail case,
Mavity.
where, you know, and it was an African American male examiner who rejected that case. So again, to me, that again shows whoever's picking up the file has at least an initial layer of bias, one way or the other. It could be, from my perspective, good bias. It could be, from my perspective, bad bias. But I don't, and there may be the situation where you can't get out of that regime, that you have to accept it. And maybe we do have to accept it on the moral and scandalous. But it's something that the community has to decide.
And I think you're right. And I think as the only brand owner, I'm not the brand owner, my company is the brand owner, but the only brand owner on this panel, I think the challenge with this decision is, at least when I work with my colleagues at my company, I always have the opportunity to remind them that in IP law, we have all of these treaties back here that set the course for what we're going to do. And so when we're thinking about in the context of TRIPS, TRIPS does actually allow countries to decide what is immoral or scandalous within the parameters of your country. And when we get rid of this in the United States, for brand owners like me, when I go for search and clearance and I'm trying to understand what marks I can register globally, there are now no cues in the US that can enable me to feel comfortable about what might go through in the US and what might go through in other jurisdictions. So just from a fiscal standpoint, this decision is inconsistent with almost every country that has signed on to TRIPS and has a similar law. So we are now the outlier, like we were in patent law for decades. We are now the outlier in trademark law, and that is difficult for companies that are actual brand owners.
Well, one interesting thing is people always ask, well, what's the effect, right? So what has happened since TAM? And so I've done some searching, and there's some bad stuff that's been registered, and some really bad stuff, some very disparaging things.
And
that I
now
would-
being applied for towards registration, now that they saw that this is what can happen.
Right, and then but yeah,
New applications.
In the way, absolutely new applications. Now there was a couple. And I'm not even going to repeat them. But there was a series of marks, and there was one company that applied for them, and I was like, oh my God, who are these people? This is horrible. Then I dug around a little bit, and it actually is the reverse of what I thought. It's a group that is applying for incredibly disparaging and offensive names to take them out of the domain, to stop other people from registering them and to block others. So I don't know how they're going to get over the use in commerce. I don't know what, maybe they'll have
Gotta use
some
use it
small,
some way.
some small use, but it's quite
I'll send
interesting.
them to your house.
But there is now a kind of a movement to take advantage of this and use registration as a way to stop others from applying for these marks.
But
Which is
think
interesting.
of the social justice aspect of this, because this could hit communities that maybe don't have money to do full search and clearance.
Yeah.
So they get something through in the United States, and all of a sudden they're in China and they want to register a disparaging mark, or they're in the Middle East and they want to register a disparaging mark, and now they can't actually enforce their mark or use their brand because they're in these jurisdictions. And you're not talking about people in this room who actually have visibility and knowledge of the law. I think you're talking about communities that aren't going to know that this might not be registrable. I think that actually has social implications.
But come on, if your mark is on the edge there,
Right.
you should at least know it's on the edge.
Right.
And understand that, you might not be able to get that one through, right?
If
You
I'm-
would before when you actually had the law telling you that.
But if I'm selling a
But-
product, I don't go near the edge, I think.
Yeah, I mean, again.
Not if the edge doesn't exist.
Well, yeah, no, because again, if you have a somewhat immoral trademark,
But
I don't know what
it's no longer defined as immoral. There's no longer an immoral trademark. There's no longer a definition.
Well,
even
wait,
you
Brunetti's
have
not over
morals,
yet.
right? So
I don't know.
Wait. Brunetti's not over yet. Brunetti's only a panel decision, okay? There's a petition for rehearing in Brunetti. Brunetti's the case that said FUCT, you heard it this morning, could be deemed to be okay because it's just free speech. So you can no longer bar that one either. And again, that's 100 years old, since the 1905 Act, when trademarks were allowed in 1905, certainly predates us, that you couldn't do moral and scandalous marks. They kept that in the 46 Act. But that's 100 years, and now that's been knocked down by Brunetti in reliance on TAM. So TAM, as I said, they opened Pandora's box. Now the First Amendment over-controls this, and now you have this problem. So Brunetti says now even the moral and scandalous marks can be registered, and even vulgar marks can be registered, right? Now that's not over. So there's a petition for rehearing. So I can't say anything about it because it's pending before the judge. But it's public.
We can. You just can't.
But it's public record what they filed, and from an en banc, if there'll be an en banc, which I recommend, but if there isn't an en banc, it's going to go to the Supreme Court. It's going to go to the Supreme Court, and I hope somebody can make a distinction at least between disparaging in TAM being a problem, but maybe not. And I know Phil has an angle on this. I'm going to turn it back to you in a second. But vulgar marks or obscene marks should not. And the line that's in the petition for en banc says, while the government generally cannot restrict the use of sexually explicit images in commerce, It is not constitutionally compelled to publish them, like in the Gazette, in order to promote their use. That, I would have written that a little different, say not compelled to publish or register them or give them greater rights as registration. So that's the argument on that one. But now you have a take on it.
Well, I mean, my big take is that, you know, I would analogize the immoral and scandalous and vulgar to our pornography
Those three,
statutes.
right.
And if we can regulate pornography, we should be able to regulate immoral or scandalous or vulgar marks. I mean, you know, granted, it's still a slippery slope, but I think that it makes more sense to say that it is possible to regulate that way than just to allow everything out there. Because if someone does get a trademark for like FUCT, and it's going to be emblazoned on T-shirts, and you got a 5-year-old, ooh, mommy, what's that, right? It gets a little bit, you know.
But Phil, they can use it whether it's registered or not.
But I think they're less likely to use. They're less likely to use. Because, I mean, if use wasn't that big of a deal, I don't think they'd be fighting so hard. I mean, if registration wasn't that big of a deal, they wouldn't be fighting so hard for registration. I mean, it's like, you know, for years, I mean, that's like, why did the Redskins care whether or not they kept their registration or not? You couldn't go out to FedEx Field and sell burgundy and gold paraphernalia with the name on it because of their common law rights.
Right.
I mean, there's nothing that says that you can't have a vulgar common law trademark.
Although it's not sure. I mean, the Supreme Court in a footnote said maybe not. They weren't. They
reserved it.
They reserved it. Yeah.
Well, they're leaving that to the Federal Circuit first.
But I find that interesting, though. You take trademark lawyers, you ask them, can you get common law rights in something that's prohibited under Section 2A?
They say we don't
Lanham Act?
answer that.
Some people say, oh, of course you can. Some people say, of course you can't.
Supreme said we don't answer that.
But nobody really knows. It's kind of up in the air.
There was a decision, though, years ago that said,
Yeah, years ago, you can sue for it as an unregistered mark. Yeah,
Yeah.
that's been the doctrine.
Yeah, you can, but the question is, if it's barred under 2A, would that give you common law rights? And I don't know the answer to that.
I think Phil's right. I think there's a case on that. But I'm just concerned, as I said, that now when you say they want to register it because it is a big deal, I would never make that argument, respectfully, because now you are making the very connection that the en banc circuit made that said there's a chilling effect if you can't register it. I don't think there's a chilling effect. I think go out and use it all you want.
but there's a chilling effect on pornography. You can't go out and go to the wrong website. So
The purveyors are out there. It's a free country.
There's still a chilling effect, right? I mean, it's one of these things where we're not going to say it's okay. If you want to go ahead and do it, oh, fine. But
don't register it.
The government's not going to say it's okay.
Well, meaning don't register it.
Yeah.
Yeah.
Don't use federal resources to register it.
Right. And it's more than just resources, it's like giving it extra rights.
Right.
I mean, the Lanham Act gives you all kinds of extra rights. You can bar importing goods, you have presumptions of validity and enforcement, you can do things about counterfeits. Gives you a lot of extra rights, no question about it. But as stated in the brief on requesting en banc rehearing, go ahead and use it, but we shouldn't be constitutionally compelled to register it. That gives you some extra.
How about that? Is there a way to distinguish the bar against disparaging marks from the bar against immoral and scandalous marks?
Well,
such
Phil
that
just
we're
gave
not
you that one. He said that the
Yeah.
things that it could be defined as obscenity should, and that scandalous and
Well, I mean,
immoral
in terms of
is
sort of
broader
content.
than vulgar and obscene. But you could try to make that distinction, at least to stop the registration of the obscene marks. Although, Justice Stewart had said, I know it when I see it. They have trouble defining what's obscene.
Yeah, but what level of constitutional scrutiny do you give it? Is it intermediate or is it strict scrutiny? Because it is somewhat content, well, maybe not content neutral, but it's viewpoint neutral, as opposed to the disparagement clause. And when I read Tam, I was like, okay, I'm going to learn a little bit more about constitutional law here. And I read it, and I was confused.
Right.
Because the court didn't tell us what level of scrutiny you need. I mean, certainly, at least the majority just passed on that question.
Right.
Right? They just went to the Hudson case and said, well, it's not narrowly tailored to its purpose. There you go, it's done. And then knocked down the government's arguments. So what's the right test? I don't know. And I know that the petition for rehearing is saying it should be intermediate scrutiny.
Right.
Federal Circuit said it should be strict scrutiny. I don't know. What is it? What should it be?
I think the government has a legitimate right, words matter. And the government has a legitimate right to, when I say the government, I don't mean some examiner just sitting alone at their desk. You say you don't make a record in prosecution. Actually, you do, because then after that 42 minutes, then the other side comes back with a response to the office action. You go back and forth a little bit, then it gets up to the board. So there is some adversarial process there. It's not only in oppositions and cancellations. That being said, I think words matter. And even in the concurring opinion in TAM, if you check it, Justice Kennedy says we do bar words that are inciting. Incitement is barred. Defamation, you can bring an action for defamation. Fire in a crowded theater, obscenity. These are categories where the First Amendment is restricted. Then he doesn't explain, however, the argument, how to get around the government's argument that that's why you shouldn't give extra rights of registration to things that could be insightful. And I don't mean S-I-G-H-T. Inciting people. I mean, look at Charlottesville. Words are dangerous, okay? So you have to consider that when you say, let's give these extra rights when you register it. Again, I thought this was answered for 70 years by the fact, go use it all you want.
Well, see, that's
But
the
let's
crazy
not
thing.
register, but don't register. And for the Supremes to address that and not even do, I consider the Federal Circuit in their en banc decision to have been more intellectually honest in taking those 7-year-old cases and saying, well, we think it's chilling. Well, at least they had a connection.
Well, Judge Moore explained all the benefits you get.
Right.
And said, well, this is really important. This
Right.
is just as important.
That's what Phil just said.
Yeah. So, but to your point, I think it's amazing to me that for how many years? 50 years. The constitutional argument was a footnote in these cases.
Exactly.
It was a one-line
Always
footnote,
a
and it was
footnote.
dismissed
Always.
outright. It was just like,
Always.
no, you can use it, you can use it,
You can use it.
The fact that that was not argued before the Supreme Court,
Yeah, that's what I'm saying.
the fact that it wasn't in, it's crazy.
I mean, you know, is it inadequate advocacy on the part of the parties or the amicus? Should I have written an amicus brief? I thought it was going to be okay, you know? But
We argued before the Supreme Court. We would have done it right.
Exactly. So, but now we get another chance, maybe with Brunetti, we'll see what happens. And the footnote certainly says it's still an open question, so that's important. But I did like the concept that, you know, are we going to have to publish these now in the Trademark Gazette for everybody to see? And we're going to have to examine them, and then you'll get
If
the
you don't
extra.
publish, are you not giving notice?
Well, no, you have to
Right?
publish if you're going to register.
Exactly.
So-
So now what do you do?
Yeah, no, they're not saying.
Then you might as well be reading like pornography.
No, they're like saying, exactly, they're not saying we can't publish it, you're forcing us to publish it. But, of course, it's 2A, this part of 2A is broader than just what Phil was saying. It's not only obscene marks, it would also be scandalous and immoral. And FUCT, even the panel didn't say that, the Brunetti panel said that's not obscene, right? So that one they were okay.
And just point of clarification, there was when we were talking about can you protect an unregistered mark that would be barred under Section 2, the case is 2 pesos. And the Supreme Court
Right.
Supreme Court in that case said, interestingly, that the same standards for registration should govern whether you have common law rights, which is not the way a lot of people think about this. So that's the case.
But didn't the footnote say, don't take our 2 pesos decision as saying that you can't bring that lawsuit if it's denied?
They said we're not going to address it in this decision.
Okay.
But they know that that's what they said. We're not going to address it here, but in 2 pesos we said this. I still think it's an open question, and I still keep thinking of, and I could say this as an Italian from New Jersey, of Paulie Walnuts and Tony Soprano in Phil's office, trying to bully him into.
And that's basically what it was. And I was very respectful.
Sono un uomo italiano, ebbene.
While we have time, are there any questions that you
Throw it out.
have for the panel?
So is there a legislative fix to this problem?
Tim, I thought about that after I saw this terrible Supreme Court decision, and you know, a lot of times you can do a legislative fix. The Supremes tell you what's wrong, and you go back to Congress, say, okay, change it this way. For the disparaging, I don't see a fix for that one. I'm not sure, they just said it's totally chilling.
You could legislatively overrule, I suppose.
No, they'll say
constitutional.
that's unconstitutional.
Yeah.
Although wasn't it that under Hudson it wasn't narrowly tailored to the purpose?
Yeah,
can you tailor it now to that?
I think the inadequacy was maybe you need some legislative findings, which you could do now. And you could say that registration gives all these extra rights and is going to encourage the use of these marks, and these marks are dangerous, and therefore the government has a legitimate reason There's a, even under strict scrutiny,
But
the government has a
Strict
compelling
scrutiny, yeah.
reason to want to restrict registration, not used, First Amendment, go use it.
Right.
But we don't have to give these extra rights. So maybe if you did some legislative findings about the government's interest in
But
it.
I think that might work for the immoral and the scandalous. I don't think it works for the disparaging, because
Why?
on the for me the example was TAM itself. Older Asian Americans did think it was highly offensive and disparaging. Younger Asian Americans didn't. So even in the community to which the slur was directed, there was so much controversy as to how do you say it. And then the other problem is, some people are saying, well, you should look at the intent of the registrant. But how far do you take that? I mean, because the dear old Washington Redskins claim that their name was to honor their first coach. So I mean, I don't think that in the intent, and we've never looked at the intent of the applicant. I remember when I was in the office, right, people objected to O.J. Simpson attempting to register certain marks. And the marks themselves I can't even remember what they were so benign.
You have to throw that out, because everything about trademark law is actually looking from the consumer's perspective.
Yeah.
So I actually don't want to know about the intent of the party registering it and whether they feel comfortable with it. I want to know the impact on the consumer.
I would agree with that.
Even if 50% of the population, the older population, was offended by it, that's a sizable segment of the population.
But how about if it's only 40% of the older population, but 60% of the younger folks?
That's why it's Pandora's box.
So in 10 years, it's going to be only 10% of the old people.
Maybe.
Well, I think part of the answer to that is, I think if the user of the mark is showing by the use, you have to have use to get registration, even in an ITU. You got to eventually go to use. So when you show your use, we get to see whether it's being
Right.
used in a disparaging way. And then even the older folks might come around. And there's a reference in the Supreme Court decision that says, well, it's disparaging on an initial view, and that's good enough for us. And I'm thinking, well, but maybe you need to see initial, meaning just in the office. You need to see what the specimen of use looks like. And I even had in my office an associate, African-American associate, came to me and said she had somebody who wanted to register the N-word, claiming he's going to take it back. And she said she doubted his true motives. Now that's an ethical issue as counsel. I'm going to outsmart my client if I think he's trying to commit a crime in the future. Not a crime, but you know what I mean.
Right.
If you see something unethical going that's going to your service is going to be used for, you shouldn't do that. You should counsel the client accordingly. No, you can't rob the bank. And if you tell me you're going to rob the bank, I resign and have to report you to the police. So, I think there are traps for this intent business. And Phil, you and Philip pointed out one of them, which is, the older people might not see that view. But I think there's an angle that he's not going to use it in a disparaging way. So the consumer shouldn't see a disparaging use if he uses it as he intended.
Any other questions for the
Another
panel?
question over there.
Oh, I was just going to make the comment, and a lot of panels have faulted the way in which the case was presented, but
Exactly.
I think Supreme Court advocates seeing that saw the problem of that you're denying a government benefit on the basis of viewpoint. So they saw that as sort of a dead end. And I think that was the line, and certainly that's what I've heard from people.
Well, they talk about it that way, that it was
Well, that's the way it came down, and there wasn't like there was a whole lot of dissent.
Right.
Yes.
Close.
They talked about it as a
Just
government
Sotomayor,
benefit.
I think
It's government
Sotomayor
benefit.
said that
Yeah.
not facilitating is not the same as denying free speech, right? So it's not actually denying, I think, a government benefit. What it's doing is not facilitating the registration of speech that offends. And I
Well,
think
that's
that's
the
different.
counter, but, the way in which the majority seemed to see it was that there are benefits to registering. One of the reasons the Redskins like the registrations, they can get ex parte orders.
Right, exactly.
Seize counterfeit
But that's why I say it goes
registers
back to
that
whether that you need to
state.
prove, you need to make that connection. If you're going to make that argument, you need to prove that there's a chilling effect by not getting a registration. Federal Circuit bought that in the en banc decision. I didn't see the word chill any place in the Supreme Court decision.
No, as I
So
said,
that's a problem.
I don't think it was really so much the chilling as the denial.
Just denying a benefit?
Denial for viewpoint, and I think that, I suggest that the arguable lack of consistency as to what was disparaging.
I can answer that,
what
too.
wasn't is-
But
The answer to lack, let me just say, the answer to lack of a government benefit is so it maybe needs to be subjected to strict scrutiny. And the government, as I said, taking most recently Charlottesville, government has an interest in not promoting and allowing to be promoted by a registration insightful words or scandalous words or disparaging words. That's a legitimate interest. Maybe you need some legislative findings to say that in the net when they amend the Lanham
The
Act.
problem also is then overbreadth as well.
Well, yeah, but, and the answer to the overbreadth and the answer to the variation is also answered in the Supreme Court decision, or maybe, no, actually it was in Brunetti, in the panel decision, where they said, when we look at what was deemed to be vulgar back in the 1920s, when this was still on the statute, the world has changed. Okay, that's unconstitutionally inconsistent. It's just the law applies what the mores is of the time, or the paradigm of the time. And that changes, just like for how many years was it that states could constitutionally say that you can't get married unless you're an opposite sex? Certain states said that. It gets to the Supreme Court and they say no. It's always been the constitutional right to marry whoever you want. And one of the questions in oral argument there, I think it was Sotomayor, said, well, wait, is the Constitution always meant that and we just didn't know it? Or has the society finally come around to recognize that, and we should say that is what the Constitution means today, and that's what they ruled. That's what it means today.
Another interesting point in all this.
That
is,
answers the variation over the decades, by the way.
You know, the Redskins case, there was a pretty thorough and lengthy decision in the Eastern District of Virginia
Right, on appeal.
by African-American judge. And he came out totally differently.
Right.
So again,
He said they could use it.
no. Judge Lee.
Who's a Redskins fan, by the way.
Yeah, he's a Redskins fan. He's a native Washingtonian, fraternity brother of mine, and all that good stuff. And
What'd he say?
and he said that he didn't have a problem with 2A.
Right, that's what I'm saying. He said you could register it and you could use it. And that was going to the Fourth Circuit, which was then suspended while the Supreme Court's reached TAM, and then after TAM said you can do it, Fourth Circuit dismissed the appeal, because now they could register Redskins, even if it was disparaged.
Yeah.
You know, we oftentimes try to think about, why courts do what they do, why do judges do what they do, from this sort of critical legal theory perspective. And I've often wondered, was this, if we can't find a complete legal explanation for it, was this decision perhaps a response to a growing feeling in our society to push back against political correctness?
A couple of people have said that.
I think it did. I think it was.
Yes, I've heard that. But it's pushing back too far because words matter, and you don't need to register these bad words. Go use them. I'm the first one to support the First Amendment.
Yeah, and by that, I don't mean that I think it was a good idea to push back against political correctness. I think that oftentimes what happens is that you can have one segment of society make a decision that we think, okay, this is it, we're going to draw the line, right? And they're so busy focusing in on this is who we want to draw the line against. They overlook the fact that this is not going to be only against
Right.
Asian Americans wanting to...
It's going to be unintended consequences.
Exactly. It's going to be all across the board. And there are some interesting parallels that I've heard some people raise, not to be too controversial, but about some of the unforeseen consequences of some of the, totally outside of the IP context, but some of the wave of stand your ground legislations, right? And some of the very horrific circumstances that we're living with today. And so this notion of thinking about, well, we know who we want to stop, we know who we want to cordon off, right? And then all of a sudden you wake up the next day and you realize, oops, there's a whole great big country out there.
Yeah, it very well could have had that purpose, but it went too far.
And look, when you get your registration, you still have to enforce it. So nobody really thinks about what's going to happen if you take it to a jury, right?
Yep.
That's a whole new world. I mean, because juries don't really care about the things we care about, and they don't think about things the way we do. So if it's a massively offensive mark,
Right.
I don't know.
Well, that's a commercial reason not to adopt an offensive mark. A commercial reason not to adopt offensive marks.
Right.
Yeah,
And I mean, that to me is that is the true social justice issue.
right.
Because at the end of the day, I think the populations that are not going to have the opportunity to get the advice and counsel that's available in this room will be the same community that will be getting that registration for $275 because they figured out how to
Right.
do it on, USPTO.gov.
Yeah, it's what
And
people do
then
it
here we
themselves.
go, and now they end up
Legal
in
Zoom.
court, or they end up trying to file overseas, and they can't do it. And here, now they've invested in something in the US, and I think it's just a population and a social justice issue.
Well, with that, I think, did I tell the truth? Was it feisty?